see it spin. I gotta say. Day. Where is the world's press? Well, we are a half hour early, so.
Yeah, it doesn't mean that's the opposite. Very easy.
Well, it's really amazing facilities.
It's beautiful, isn't it?
Well,
It's personal here,
No.
but I just got this movie no contact
No, that's not accurate. You can see the tax higher than that. What she said was that you had made a request in July. The last response was in May of 2015.
So when you told me that you had spoken to Gerald Cohen on the phone, you weren't fibbing at that time.
Heavens no.
Well, Gerald Cohen said she did not represent that client in this matter or any matter at that time.
Well, I don't know what she told you, but
Well, you should. I wrote to your boss about it at lunch, Mr. Holmes. So any reason they waited till the 11th hour to provide those declarations?
Why don't we just,
yeah,
Let's
let's
have
have the
our
hearing
argument, yeah.
instead of an interview.
thanks.
It's a mysterious case, isn't it? Shrouded in mystery. Why is the city partnering up with the chief suspect? Oh, I know, because they've always been partnered up with the chief suspect. Before the
Are you
time it
conducting an
happened.
interview on your camera right now?
Yeah,
what's
he is.
going on?
Yeah.
He's very good at interviewing himself.
This interview may be recorded for customer insurance purposes. But you've had no contacts with the chief of police either, is that correct?
We're gonna wait until the
Yeah,
hearing to
that's-
answer questions, so you can keep asking, but we're not gonna answer any
Right.
Well, I know
questions.
you are.
That's Jessica Nadelman, she's the co-counsel in this case.
Mr. Lee, there's two forms I could see what I need you to fill out. Seating chart and closing.
So just for the record, the hand photo and the foot photo, were those leaked or were those released?
Those are released.
So, and you had the family's authorization to release those body photos?
Like an interview, we'll have oral argument.
It's shrouded in mystery. So did Szynski question you on matters of good taste, or are we subjected to Szynski's good taste only? If somebody decided to release photos of his body, including his hand and his foot, that would be okay. And that was under the wisdom of Mike Szynski. the wisdom of Mary Perry ESQ. And it's not at all clear whose wisdom we're relying on, is it? Matters of good taste. By the way, have you seen the photos?
Yes,
You've seen the whole set. You've seen the suppressed photos.
I wouldn't call them suppressed, but I've seen photos, yes.
You've seen photographs of Cobain's head and face,
Yes.
and they are intact.
So how you define that? And
Is his skull round, or does it take some other form? Does his face look like a face, or does it look like some sort of blue plate special at Dixie's Diner?
it's clear that he has been shot.
So when you say skull intact or skull not intact?
I'm
Okay,
not a
we're gonna
forensic
stop.
expert, and this isn't the
Was the
place.
skull of a roundish shape or not?
You're quite a pressing journalist, Mr. Lee. We're not
Yes.
answering any more questions. We're waiting for the argument to start. Thank you.
You know, it's not about me, it's about the matter at hand.
Yeah, well.
That's
my
right, and
God.
this is a
Someone
public
else
records
interview.
case, and that's what we'll discuss.
Did Kurt Cobain die of a shotgun wound?
No response.
Have you seen the photos? Natalie?
Yes.
Was his head intact?
I'm not answering any questions. You can read the police report.
And the judge can do an in-camera review if she chooses to do so.
Human-like face or blue plate special at Dixie's
Not
Diner?
answering any questions.
My gosh, those are important questions. The world is waiting to know. Well, you're one of the privileged few, two of the privileged few. Who else has seen these photos? Has the police chief seen these photos? Kathleen O'Toole, Chief of Police, City of Seattle, is going to turn this into the finest police organization in the nation. Has she bothered to have a peek? Because I'll tell you, most investigators are very curious people. It seems to me that the chief of police should be very curious as to whether this individual died of a shotgun wound or not. Have you revealed any documents that indicate communications with the chief of police on this? I mean, I can ask that question when the judge comes in also.
Oh, we've responded to all of your public records requests.
Have you had communications with the chief of police?
The records speak for themselves, Mr. Lee.
Well, I haven't found them. There's been an onslaught of thousands of files. I'm just not finding that. I certainly know she doesn't respond to my letter.
All rise. Each County Superior Court is now in session. The Honorable Procedural presiding.
The matter of Richard Lee versus City of Seattle, it's cause number 14-2092920. And Mr. Lee is here representing himself. Very good. And the city is represented by
Mary Perry, Your Honor. It's up to you. I prefer the bench.
Okay.
And you, please. Your Honor, there's no dispute in this case. Mr. Lee failed to comply with the statutory requirement of RCW 4.28.080 regarding service on a municipality. And he failed to do so within the statute of limitations. As a result, dismissal with prejudice is the only option in this case. RCW 4.28.080, subparagraph 2, says that the summons shall be served by delivering a copy to the mayor during normal office hours to the mayor or the city manager's designated agent or city clerk. The designated agent for service in the city of Seattle is the city clerk, according to the municipal code. The two places where Mr. Lee could have served his complaint and summons was the mayor or the city clerk. The plaintiff on notice before the statute of limitations had passed. That is exactly what the city did with Mr. Lee. The city told Mr. Lee in its answer, and although it's not in the record, I had a follow-up telephone conversation with him where I specifically told him that he hadn't served the city appropriately. He never...
Okay, this is on May 28th, 2014.
Yes, Your Honor, that's correct. He never did anything to correct the thing they did.
It does, I read all the cases that were cited in both sets of briefs, and the statute does seem to require strict compliance, unless there's some really good reason, like in the Medina case where really it was impossible to serve this Civil Service Commission because they're part-time and the office wasn't open.
Well, I don't see a commission being part-time as being impossible to serve. It's a difficulty in service.
And your difficulty was you didn't want to serve the mayor, but you could have had somebody else serve the mayor, or you could have served the city clerk, right?
Well, I served the city attorney. And foolish of me for thinking that the law department is where legal complaint and summons should go. I made a mistake. I understand that. But, you know, I got the big book on summary judgment from the law library by Ms. Baker, and my understanding of the Skinner case is that it is asserted in these sorts of hearings as representing substantial compliance. The mayor of the city of Seattle has not been served directly. Okay, the mayor of the city of Seattle has not had anything to say about this case. He would have nothing to do about this case. All of the mayors of the city of Seattle for the last 21 years have run from the implications of this controversy. So it would have gone to Mayor Ed Murray's front desk, and they would have said, Mr. Mayor, do you want to become deeply involved in this controversy? And he would have said, heck no, send it over to the law department. They're the ones who are going to be handling this. So I believe that the city's been substantially...
But back to the statute, and the problem is that the statute RCW 428, the rest of the site, does seem to have been interpreted as requiring strict compliance because that's what complains that gives this court jurisdiction to have. And it looks like the exceptions are very, very slim.
And so you're not familiar with the phrase, the doctrine of substantial compliance?
No, I am quite familiar with that.
And is that a doctrine or just something that's applied in very few circumstances?
It's applied in very few circumstances in this situation, under the case law interpreting the statute. And the cases hold that it's jurisdiction, but the court lacks authority. But in any event, did you want to go on to the other issues? The city argues that under the Public Records Act statute that your suit was premature. You waited only 3 days from the time they got your request to file this action.
Well, I'll address that by saying that I made my first request for documents in this case in 1994. I believe it was the Monday or the Tuesday after the body turned up of Kurt Cobain, and that was hand-delivered to an individual named Sean O'Donnell of the Seattle Police Department. That record, strangely, has never shown up in the records releases, but I am quite certain that's precisely what happened. I also had a case in the late 90s where I attempted to pursue this course of action, but ultimately withdrew the case, seeing that it was kind of a fantasy of mine to think that the case would prevail to the extent that the police department would actually develop these films and hand them over to me in any case. Even if I were to win the case, it is so very, very easy to destroy films or just say that nothing turned up in them. And I came to believe that it was foolish to pursue the case, better to withdraw and perhaps live to fight another day on this. Nevertheless, these requests have been ongoing and formal from me since 1994. There's a standard set of documents that the Seattle Police Department does release to people who put in public disclosure requests for Kurt Cobain material. That was brought about by my working with an attorney by the name of Hendricks of the law firm of Hendricks and Lewis. Strangely, she quit the cause, probably quite unethically, and then her firm ended up representing the decedent's widow, Courtney Love, in court several years later, which of course most of us would see as a flagrant conflict of interest that they should have avoided by not representing that person. So my requests have been ongoing for the last 21 years. Have they argued successfully that all of these previous requests are somehow invalidated by the new appeal? I don't know. All of the language that they provided to me has to do with tolling and expectations of other procedural issues. It seems to me that often in these cases there has to be a public policy exception. There's an overriding public policy issue here as to whether the Seattle Police Department and the King County Medical Examiner participated in the murder by concocting a fraudulent death investigation and misinforming the public from day one, from hour one. They declared it to be a suicide and nothing else but a suicide, could not possibly be anything else. And by the way, the cause of death was shotgun blast to the head. So this is a subject of international and national news as of the last several days. People are very interested to know whether the Seattle Police Department Homicide Squad somehow got into the business of sanctioning homicide in the case of the murder of this individual. And if one photograph is released by the Seattle Police Department that demonstrates that Cobain did not die of a shotgun wound, people are going to have a little choice but to agree with the plaintiff that Cobain's death investigation was a complete falsehood. And there are obviously implications for how law enforcement does its business that follow from that. So let me cite a public policy exception concept here. Also related is legislative intent. Did the legislature of the state of Washington, in its authorship of the Public Records Act, really believe that the average citizen was going to be able to comprehend all of the multiple issues involved in these intricacies of personal service, whether the city of Medina is open part-time or full-time, whether the mayor of the city of Seattle would be available to receive the summons and complaint, or whether armed but unidentified undercover police officers would seize upon the process server or the plaintiff. I don't think that the legislature was either intending to deal with these issues or anticipating that all of the intricacies that have been cited by the defendant so far should bar the average citizen from bringing a public records request, and when making a public records request for documents that are controversial that the government does not want to let loose, that they would have to spend tens of thousands, hundreds of thousands of dollars to hire an expert on the level of Ms. Perry in order to bring their public records request to fruition. Ms. Perry is the editor of the Washington Handbook, or an editor of the Washington Handbook on Public Disclosure. How many attorneys in the city of Seattle or the state of Washington are going to be able to match her thrust for thrust on all of these procedural issues? Very few.
Yeah, 5 more minutes.
I have 5 minutes. Well, so I didn't go to law school. I went to paralegal school, and we dealt with issues of personal service. They didn't get into quite so many esoteric areas. I mean, we were told that you can serve process on a minor. Happens all the time. Teenagers, if the process server speaks to the teenager and decides that this teenager is competent, mentally competent, even if they're the age of 13 or 14, here, give this to your dad, give this to your mom, you've been served, thank you very much. Now, there seems to be an entirely different standard at play when a highly expert attorney like Ms. Perry is asserting that, we should all divine from the part-time nature of the city of Medina that in that particular case, difficulty of service is an overriding issue. In all other cases, it does not apply because, people in Seattle aren't out playing golf half the time like people in Medina. She's asking for not only summary judgment, but she's asking for dismissal with prejudice. She doesn't want me to, the city does not want me to refile this case. So they're asking for dismissal with prejudice. But under CR 12b6, has she really specified, has Ms. Perry really specified, that it appears beyond a reasonable doubt that no facts exist that would justify recovery? I didn't hear that argument made, and so I'm citing Atchison versus Great Mining Malting. And certainly there are facts that would demonstrate prima facie an opportunity for recovery by the plaintiff. Again, my apologies to the court for not conforming precisely to these intricacies that I did not anticipate. I don't recall Ms. Perry saying on May 28, 2014 that I was out of compliance with process. However, if she had, I probably, took it with a grain of salt. She also told me on that occasion that she was in contact with the attorneys for Francis Cobain and Courtney Love, and that they were parties to this suit, that they were going to be parties to opposing this. And yet, I see no record of contacts between Ms. Perry and those attorneys in the last 15 months, and yet the declaration showed up completely by surprise less than 2 weeks ago. So, I immediately called a Ms. Gerald Cohen in Los Angeles to say, well, Ms. Perry's told me that you represent Ms. Francis Cobain in this matter. Gerald Cohen said, I definitely do not represent her in this matter, do not represent her in any matter at this time. So, whatever Ms. Perry may or may not have said to me on May 28, 2014, very hard to believe much of what she had to say, and obviously, given the nature of her practice, which is to work against the public disclosure of public documents, a procedural attack is definitely something I anticipated. And so here we are today. In any case, CR 12b6, did she even argue today that no facts exist that would justify recovery? No. She just came to court and asked for summary judgment plus dismissal with prejudice, meaning that I can't refile the case. Even if this case is dismissed without prejudice, do we really want to start the clock again after 21 years? We all know that these materials have been held by the Seattle Police Department for 20 years solid. Then they were developed through a highly mysterious process resting almost entirely, apparently, on the judgment of one cold case detective, Mike Szynski. And Szynski, apparently drawing on his own wisdom and no one else's, decided that over 30 frames of this would be released, including a frame of Cobain's foot and Cobain's hand. And at the same time, Szynski's wisdom led him to believe that photos that would show Cobain's skull or the area around his body directly or his head should be suppressed because of issues of taste that Detective Szynski rather forcefully put across. In fact, he rather forcefully put them across in a way that led us to believe that Detective Szynski would prefer that those frames not exist. And that is not surprising because, to my knowledge, those frames will demonstrate that Cobain did not die of a shotgun wound and that the Seattle Police Department and the King County Medical Examiner have been lying about this all these years. So, do we really want to start the clock again, have me refile this case, or perhaps the case will be taken up by someone else with less expertise in this matter who will fail to get to the heart of it in a factual manner? The factual matter at hand, which is, what do those photographs show? Why is it that the so-called suicide note has been suppressed in a clear photographic form for over 20 years? And the answer to these questions are, lack of a shotgun wound to the head will demonstrate that the death investigation was a complete fraud, and a close-up photograph of the so-called suicide note will demonstrate what's been argued, I think, very successfully by myself for over 20 years through cruder representations of the so-called suicide note, which is that it is an elaborate forgery. So I don't see the basis for dismissal with prejudice. If we're going to start this process all over again, I think that does not serve the public's interest. It's contrary to public policy. It's contrary to legislative intent. And, at this point, I think what the world wants in terms of this case is justice by means of public disclosure, not adherence to the law as practiced by only a handful of the most expert public disclosure lawyers in the state of Washington.
Very much, thank you. All right, and Ms. Perry, did you wish to present your full argument?
Very briefly, Your Honor. The statute of limitations period under the Public Records Act must be dismissed with prejudice. Thank you, Your Honor.
All right, thank you. The court will grant the city's motion for summary judgment. And there's nothing barring you from making another public records request. All right, so for those reasons, I'll grant the city's motion. Ms. Perry, did you want to draft an order?
Yes, Your Honor, I have one, however, I'm not sure it covered every facet of what you indicated.
I'd like to file that as soon as possible, so if you want to take some time to review that and make some additions.
Yes, Your Honor.
It'd be fine. We have forms that Madam Mayor can give you as well.
Thank you.
All right, thank you.
And Your Honor, if I may ask you to be crystal clear, this is not being dismissed with prejudice.
This lawsuit is being dismissed with prejudice because it's based just on the one records request that you made on March 20th, 2014.
But the dismissal with prejudice does not, in fact, bar me from a refund.
This ruling is based just on that one records request. That's what I can tell you. All right, thank you.
All rise.
Oh, right here is fine? Or?
I guess so. I don't think it's good here.
I don't think anyone else is.
No one else wants to talk to you?
No, I mean, I don't think there are any other cases.
Okay, well, let's go outside and call one of them.
So this would be.
Sure.
Okay. So let's begin with your name.
Richard Lee,
Spell it.
R-I-C-H-A-R-D-L-E-E.
Mr. Lee, the judge dismissed your case, the filing that you made in March with prejudice, which means you can't file this one again. What is your reaction to that?
Well, I sent out press releases, and there's been a worldwide level of interest in this case. And I'm rather surprised that this came down only to technicalities of the law. Basic principle in all of legal proceedings is to move things along and not grind them to a halt once they've gotten up and running. And in this particular case, this judge has decided to grind this thing to a halt, at least for the time being.
You say time being, will you refile?
Yes, of course. I will refile, yes.
Why?
Well, because, it's historic. One photograph of Kurt Cobain's head in an intact form with his face in a relatively undamaged form is going to demonstrate to people that Kurt Cobain did not die of a shotgun wound, and therefore the death investigation is essentially a fraud. Why the judge would want to draw on technicalities to halt that progress is beyond me.
What would the Seattle Police and the King County Medical Examiner have to gain by not saying he was murdered if indeed he was?
Well, I didn't get to go into my main soliloquy here, but the most important thing in Seattle, Washington, or Moscow, or Pakistan, or anywhere else is that the murder squad, the homicide squad of any jurisdiction cannot be allowed to go into the business of sanctioning murders. And it's quite clear that with $500 million, $1 billion up for grabs in Cobain's fortune, that corruption is clearly indicated.
On the part of the police.
And the medical examiner. Gee, how would such a thing occur? How is it that corruption could occur where people in show business would have the opportunity to perhaps pay a bribe to the King County Medical Examiner or the Seattle Police Department Homicide Squad? How would that happen? Does anybody know the answer? Dr. Nicholas Hartshorn, the late Dr. Nicholas Hartshorn, was some sort of an associate or friend of Courtney Love's for years prior to the death of her husband. He is the individual from the medical examiner's office who signed the death certificate. How is it that a friend of Courtney Love's, who knew her for years, ends up being the person who signs the death certificate? It's a troubling coincidence or a troubling indication of corruption in this case.
So you do plan to pursue it because you would like this to come out?
Absolutely. There are two main components to what needs to be understood in terms of seeing this as a homicide and not a suicide. A, the suicide note is a fake, it's a forgery. The somewhat crude copies that have been out so far capably demonstrate that. There's no cursive movement in the suicide note. None. Zero. Does not match Cobain's handwriting in that regard at all. And the most startling of all is, of course, that Cobain did not die of a shotgun wound. A shotgun wound is the most distinctive of all wound patterns in all of ballistics. And everything that I've understood to date for the last 21 years indicates that not a drop of blood is seen in any of the photographic evidence that's ever been published. And certain individuals who have seen the body have told me, no, he could not have died of a shotgun wound to the head.
Can I put a microphone on here really quick?
A microphone, sure, yeah. Oh, no, I got it. Okay, that should be right. Are you with Five?
I'm with Team 5. I'm also new to town, so I'm new to you.
Oh, your name is Lee also.
Yes.
You're Danielle Lee, right?
Yes, but it's spelled a little differently. So
Right.
give me a little background of why is this particular case this particular murder so important to you?
Sorry. Let me just deal with my equipment here. Well, Danielle, thanks for asking the question. As you've seen from the press coverage that's occurred so far, the whole world is interested in this case. And they're interested because Cobain has achieved this iconic status as, you know, one of the top rockers of all time. And I would like to think that many people are interested in the case because they see Cobain as being a very decent and very creative sort of a person. And the idea that he was knocked off by a scandalous spouse, in this case, who sometimes behaves as if she knows that everyone suspects her of murder, is a very, very, very sad turn of events. Cobain should have been allowed to live his life in full, and we all would have been much enriched by his presence in American life as a public figure. But that did not happen. And so, you know, was Cobain murdered for his money? Probably. Was he murdered for other reasons? Possibly. But with $500 million, you may know that his estate is valued at $450 million now. Somehow it was valued at only $450,000 at the time of his death.
Were you a big fan?
I just never answer that question because, you know, you hang the word fan on me, and fan is short for fanatic, and then all of a sudden I'm some fanatical person. But let me just answer it this way, which is that I enjoy good music. I've been involved in music most of my life, and Nirvana's good music, so I enjoy Nirvana music, but I just cannot cop to the fan title, obviously.
In your earlier interview, I was listening to you talk about concerns about corruption. And so I guess, do you think that the police were corrupt just in this one instance, or are there lots of cases of corruption? And if that's the case, why aren't you kind of expanding your search of what this police department was doing in this time? Why focus just on Cobain?
Well, you're new to town, Danielle, as you pointed out. So I began this program of mine. The first airing of it was 5 days after the body was discovered. And actually, one of the criticisms that I faced most often is, why doesn't he do all the shows about Kurt Cobain? Why does he take on other police scandals and other police shootings? And so I have examined Seattle politics and policing in depth for 21 years. That's a part of the program. So I have looked at, you know, right now with these body cams, the public is going to see a never-ending series of troubling shootings. I mean, the one that occurred yesterday, where the video was released yesterday, is actually the first body cam homicide that we've ever seen. And because of the photographic evidence in that case, that officer is now up on murder charges. As where if there was no photographic evidence, wouldn't it have been dismissed as simply a justified shooting, like 99% of all of the cases in King County?
So did you find other evidence of corruption around that same time then?
Well, it depends on what you mean by corruption. Corruption can be people being paid off to do something they shouldn't do.
And have you proven that in other cases?
Well, if you're asking me if I have some film of somebody handing Dr. Hartshorn a big fat stack of cash, no, I don't have that. But understand the standard of corruption under cases that the Justice Department of the United States pursues. If public officials do not do the job that they are being paid to do, they are defrauding the taxpayers of their honest services. So even if you believe that the homicide squad and the medical examiner went into that death scene and said, you know what, we don't want to do all the work of an elaborate murder investigation, so we're going to call it a suicide because that's the easiest thing to do, that's still fraud, that's still corruption. The Justice Department could pursue that case on a basis of corruption.
Safe to say, though, you will reapply for this document.
Absolutely.
All right. Thank you.
Okay, thank you.
I think Matt still, which you guys are done, Matt went to do an interview.
Okay.
Were you surprised by the decision? I mean, is it what you expected?
My understanding is that there are many, many opportunities for judges to go the other way on this, which is to say public policy exception, legislative intent, and, compelling public interest in having the truth come out in such a case. This judge didn't do that.
Richard, Matt Markovich.
Okay, hi, Mark.
So, I want to be in your shot here, okay?
Oh, you want to be in the shot?
No, I
Okay.
just want to let you know. So we're from Como.
Yeah.
So let me just,
I'm going to ask you to hold that above the key. There you go.
okay. So just to be clear, for according to the city in the briefing, you've basically had 19 of these requests, my understanding with the city.
Well,
And-
just to touch on that, what you have to do is, all of this is surrounded by all of this legal technique. So you think you make a request, and then as documents become available, they send them to you. But in fact, what they really require is that you write to them like every 2 weeks and say, give me whatever you have now.
Right.
And then they make you wait 6 weeks or whatever it is until they finally release something. So it's a very messy process.
Well, but you, the same requests you've made, maybe in different forms, but you're still going after the photos. You've been made 19 different times, and they basically, a lot of them come back as the same exemption. I mean, they're still pending, from my understanding. Some are still pending. They come back with the same exemption. They're going to initiate the same exemption. Are you just not satisfied with that?
No, if you read Mary Perry's briefings, it does make me look eccentric that I asked 19 times. That doesn't have anything, it's not eccentricity. It's that you ask them for stuff on April 1st, and they give you what's available through April 1st, and then if something comes along on April 2nd, you'd better ask on April 15th for the last 2 weeks of stuff, or they're not going to give you anything. So they require that you do these and then once you've done the continual request, they make it look like you're some sort of an eccentric for continuing to ask again and again. But it's just the procedure that you have to go through. It's kind of a non-issue.
It's a non-issue, even though, I mean, we all know about your pursuit of all this. So.
Well, the real issue is that I went into the Seattle Police Department the week after the body was discovered, and I handed Sean O'Donnell, the media officer, a request for all of the available documents. And I've been requesting these documents since 1994. I won the initial release of the first 85 pages or whatever it was, which opened the case up to scrutiny.
I know, but I guess what I'm asking for is that you keep on getting the same exemption. They're going to keep on giving you the same exemption that they've given you before, that they're not going to release these photos. At what point are you going to say, what point is it going to be different for you?
With a trial. That's what the trial is all about. The trial is they come to court and they say, this is offensive to a reasonable person, and it does not pass muster on that standard. And I say, well, it's not offensive to a reasonable person because there's compelling public interest in seeing what appears to be evidence of police corruption falsifying the death investigation.
So, and why in this particular case did you file 3 days after and not wait its full course? It would seem like it'd be easy dismissal by a court judge because you didn't wait 3 days. I mean, you only waited 3 days to file a suit.
I was concerned, based on the statements of Detective Szynski, that he was very eager to destroy these materials. He made statements about how offensive he found these materials to be, and it seemed to me that it was very much in the cards that Szynski, all on his own authority, not the chief of police or anyone else, might just decide that it was just bad news for everybody to have this stuff around and toss them into an incinerator. Mm-hmm. So I acted perhaps too hastily. But then again, I didn't really see a procedural attack succeeding. I came to court today expecting to win.
Mm-hmm. And you were hoping to get that public records fulfilled, right? Is that what
well, not today. They would have to go to trial, and they would have to examine the issues of whether this is reasonably offensive to a reasonable person, or whether the public's interest overrides any concerns about reasonableness and offensiveness.
2 more questions. What are you going to do now?
Refile.
Okay. Same request that you've refiled before?
Similar, yes.
Mm-hmm. And you're going to keep on doing that until when? Again,
Matt, it's not an eccentricity to try to cope with these. The eccentric thing that went on here today, quite frankly, is that the city of Seattle paired up with the main suspect in the case and said, well, Courtney Love doesn't want this material released, and we're going to vigorously defend her right to suppress its release. Well, what about the public's right to see this material?
Mm-hmm. Okay. And one person in our newsroom asked the main question, which is, why, you say it's not eccentric, why are you continuing to pursue all this? Why are you somewhat obsessed about this case?
you know, people call you obsessed. Courtney Love called me obsessed, and then she had sheriff's deputies come at me with guns drawn. And I got the impression, this was in 2005, that I could have lost my life. So, you know, I'm trying to be polite about this, Matt, but frankly, you call somebody obsessed, and it's like you're saying, are you saying that I'm mentally ill? I mean, that's really offensive and totally unjustified. Is that what you're saying, Matt?
No, I'm asking a question.
And a person who's obsessed with pop culture figures is almost by definition,
I guess,
some sort of ill person,
No,
and
no.
I'm certainly not that.
how about, I'm going to pick a word here. Addicted? Addicted to
I've never been addicted to anything. You know, this is the same thing they threw at Cobain, you know? He dabbled in drugs. Dabbled was the word he used. Addicted is what everyone else used.
Okay.
But, you know, when I was 11 years old, there was the first airing of the Zapruder film on ABC TV, in fact, your network, and Geraldo Rivera on Good Night America introduced the Zapruder film for the first time to the American public. And I was a kid who, you know, went up to the TV screen with a 35 millimeter camera and took a picture of it because it was introduced as the evidence in this homicide case that the government will not allow you to see, has not allowed you to see for the last 11 years. I wanted to get a photographic record of it. The photographic record of the evidence in this case should capably demonstrate to any reasonable person that the death investigation was fraudulent. And that's a very important thing to establish if we're going to keep a tight rein on our law enforcement agencies. Those are my interests.
Okay.
Not rock and roll stardom and all that.
Okay.
Just need somebody to grab a stuff.
Yeah, sure. Be happy
Thank you
to.
very much.
Yeah. Oh, hi, Sammy. How you doing?
Hi, I'm good. I just have one follow-up question from you. I think I got a lot of answers from what everybody
One
was
question.
But when you said you plan to refile, so are you gonna file another public records request and then
That would be the
potentially-
first steps, yes.
And then potentially sue after that one if you're not happy with the results?
Well, the results are predictably going to be the same. They're not going to turn over the photos. We know that, right?
Could you spell out the next steps for me then?
The next steps are to wait, are to file a public records request, which I'll do this evening, and then wait the appropriate level of time so that we don't face this sort of procedural attack again the next time around.
And that's before you file another?
Another suit, absolutely yes. Another suit in Superior Court.
And what are you gonna ask for in the records request?
Anything and everything that they have, including all of the photographs, including all the close-up photographs of the so-called suicide note.
Okay. You came in today expecting to win?
I did actually, because, you know, look at the way these cases usually proceed, especially when there's a lot of publicity. It's not usually the case that the person who's arguing for suppression of the public's right to know wins because of issues like, I didn't slap the complaint and summons into the hand of the mayor of Seattle. You know, there's another case that they draw on there where it says that you cannot serve the secretary of the mayor of Seattle or the mayor of any city. You must pursue personal service of the summons and complaint to the actual mayor of the municipality that you're suing. Well, I was not aware of this, but doesn't it sound rather absurd? These people are surrounded by, obviously, police bodyguards. Slapping something into their palm is not the easiest thing in the world. And I've never heard of any case where, I mean, other than the one cited, where, you know, a cause of great public importance was defeated because of what most people would regard as, frankly, trifling technicalities.
Thank you for your time.
Okay, Sam.
Sorry, I'm just like jotting this down. Thank you.
You've got the Samantha Agar haircut, too.
So I wanted to know if I could get...
Well, a judge has ruled that a lawsuit to release photos from Kurt Cobain's death scene will not move forward. A man who runs a public access TV show sued the city of Seattle and Seattle police to release records and photos from 1994. He believes they will confirm his theory that Cobain was murdered. The city argued the photos should stay private for the family's sake. Today, the judge ruled that the man did not follow procedures.
It's the latest in one man's decades-long obsession with the death of Nirvana frontman Kurt Cobain.
Today, a King County judge dismissed a case with prejudice filed by Richard Lee. Lee was seeking graphic photos of Cobain taken by police in 1994. Judge Teresa Doyle says Lee made procedural errors like failing to properly serve the mayor and added that he could resubmit his request for the photos with the city. Cobain's family has requested the photos be kept private. Lee has a public access radio show and has used it to argue that Cobain did not die by suicide, as police have reported, but was in fact murdered. He says the pictures will prove his position and plans to resubmit his request.
New at 6, a denial. The latest attempt by Public Access, a TV host, to get more photographs from the scene of Kurt Cobain's death. But KCWM7's Deborah Horn tells us tonight the ruling is not likely to stop his quest for death photos from Nirvana's frontman.
Seems like a suicide to me.
Why?
Because, he seemed troubled and he was depressed.
Indeed, Seattle police released these photographs from the scene of Cobain's death in advance of the 20th anniversary, insisting they prove he ingested a lethal amount of heroin, then shot himself.
Cobain's death investigation was a complete falsehood.
But public access TV host Richard Lee had tried and failed 18 times to force Seattle police to release graphic photographs that he says will prove Cobain was murdered. This 19th time, the city attorney asked the judge to dismiss his claim because he had not followed the proper procedure for filing it. The judge agreed. Afterwards, we asked Lee his reaction.
I'm rather surprised that this came down only to technicalities of the law.
Despite today's ruling, Richard Lee says he is unwavering in his belief that whatever happened to Kurt Cobain inside that house more than 20 years ago was a case of murder. And he will continue seeking the photographic evidence he says will prove it. Reporting in Seattle, Deborah Horn, KCWM7 Eyewitness News.
The judge agreed that Lee can keep trying to get the photos, but the Seattle city attorney says state law allows the photos to remain under wraps to protect the privacy of Cobain's survivors.
Today, a King County judge dismissed a lawsuit over unreleased photos of Kurt Cobain's dead body.
Richard Lee, who believes Cobain was murdered, has spent years trying to get the pictures made public. Come Force Matt Markovich reports.
Richard Lee doesn't believe Kurt Cobain killed himself April 8, 1994, but was murdered. And the police, the medical examiner, Cobain's rock star wife, Courtney Love, all played a role in the cover-up.
Hello, I'm Richard Lee.
For 21 years, he's been trying to convince people on his public access show he's right.
No blood at the scene of the crime.
And to prove it, he wants Seattle police to release the gruesome images of Cobain's self-inflicted shotgun wound to the head. Police did release some pictures last year on the 20th anniversary of Cobain's death, but Lee wants all the pictures, a public records request he's made 19 times, but this time he's suing.
Because there's compelling public interest in seeing what appears to be evidence of police corruption.
Even before the hearing began, Lee, known to be a self-promoter, set up his own camera in court.
You say skull intact or skull not intact?
I'm not a forensic expert.
And began questioning the city's attorney before the judge showed up.
Was the skull of a roundish shape or not? Did Kurt Cobain die of a shotgun wound? My gosh, those are important questions. The world is waiting to know.
But the question before the court wasn't on the merits of Lee's request, but how he requested it. The city argued he didn't submit the public records request properly and filed suit against the city just 8 days after the request was made. The city has up to a year to respond, but Lee wanted to talk murder conspiracy.
That Cobain did not die of a shotgun wound.
The judge sided with the city and threw out the lawsuit.
You call somebody obsessed, and it's like you're saying, are you saying that I'm mentally ill? I mean, that's really offensive and totally unjustified. Is that what you're saying, Matt?
Lee plans to request the photos for the 20th time.
In Seattle, Matt Markovich, KOMO 4 News.
Thank you, Matt.
Richard Lee has spent more than 2 decades trying to get the photos released. He represented himself in court today. KOMO 4's Matt Markovich reports Lee doesn't think he's obsessed with Cobain.